Is the background okay? I don't know what you can see.
Good.
Is the light too bright right there?
I don't think so. You look like you have a halo.
Oh gosh.
All right, I'm getting the closed captioning.
Maybe I should turn that off.
Giving everyone time to log in from the waiting room. All right, the closed caption should be up. You'll see a little red live button on your screen.
Am I too dark right now?
Hold on. Nope, that looks good. So you can click on the red live button to see the closed captions. And I'm also going to copy that link just in case you have trouble clicking on it and put that in the chat. So welcome everybody. Thanks for joining us this morning. I'm glad to see there's so much interest in this training. And I am so grateful to Anna Bernal Roberts for coming back so soon after giving us the last great training. So I really appreciate her time. And I appreciate the Legal Aid Society of the Orange County Bar for letting us borrow Anna for 2 trainings in a row. I did apply for CLE credit. I have not heard back yet, so I'll email everybody as soon as I get that CLE number. And I am going to go ahead and pass it over to Anna. Hello,
everybody. Today we're going to be talking about dependent youth and special immigrant juvenile status. I'm an attorney at the Legal Aid Society, and SIJs are some of the cases that we handle. So what's special immigrant juvenile status? It is federal immigration relief, which provides a pathway for undocumented youth to obtain lawful permanent residency and eventually citizenship. It is for eligible children who have been abused, abandoned, and or neglected by one or both parents and meet other requirements. It requires certain determinations to have been made by a state juvenile court. It was enacted in 1990 and it was amended in 2008. It is found in the Immigration and Nationality Act at INA section 101A 27J, and it's codified at 8 USC 1101A 27J. Federal eligibility requirements for SIJs. The youth must be under 21 years of age. The youth must be unmarried. Youth must have been declared dependent by a juvenile court. The juvenile court must have found that reunification with one or both parents is not viable due to abuse, neglect, or abandonment. And the juvenile court must have found that it is not in the child's best interest to be returned to his or his parents' country of nationality or last residence. SIJ's requirements. In Florida, the predicate orders for SIJs must be obtained from the juvenile court prior to the youth's 18th birthday. The orders that must be obtained are the order of dependency and the special interest order. Applicant must be under 21 when the SIJ application is filed with the United States Citizenship and Immigration Services. Florida has statutory protections for immigrant youth in dependency court, which allow for the extension of jurisdiction until the youth's 22nd birthday. Juvenile court should retain jurisdiction until the entire immigration process is complete. Juvenile court is defined under federal regulations at ACFR section 204.11a as a court having jurisdiction under state law to make judicial determinations about the custody and care of juveniles. No youth can be denied SIJS on account of age as long as the youth was under 21 when he or she applied for SIJS. The definition of child is governed by state law for obtaining the predicate order. You can see matter of AOC. State foster care. So does the youth need to be in state foster care to qualify for SIJS? So previously, the statutory definition stated that the child be found eligible for long-term foster care in the sense that family reunification was no longer a viable option. However, this eligible for long-term foster care language has been eliminated. The new language states that the child's reunification with one or both parents is not viable due to abuse, neglect, or abandonment, or a similar basis in state law. So what does the state court do? The state court reviews the facts and makes factual determinations and must determine under relevant state law the following: whether the child should be adjudicated dependent or legally committed to or placed under the custody of an agency or department of the state or an individual or entity. It must determine whether reunification with one or both parents is not a viable option due to abuse, neglect, abandonment, or other similar basis under state law. And it must determine whether it is in the child's best interest not to return to the child or the parent's home country or country of last habitual residence. What does the state court not do? The state court is not being asked to make any immigration decisions in an SIJS case. The predicate orders, which are the dependency and special interest orders, detail findings of fact. A predicate order does not confer any immigration status to the child, nor is it a court opinion on whether a child should be granted immigration status. Only the United States Citizenship and Immigration Services decides whether to grant SIJS. So the phase one is through the state court process. The SIJS process begins with filing the appropriate petition with the state juvenile court, such as the dependency under Chapter 39. I know that there are other orders that can, cases that can be filed, but for the purpose of this training, I'm just doing it on dependency. And I'm not the one who actually does these cases. When the cases come to me, they've already gone through the dependency phase. And so when I get involved, that's already been done, and I'm just dealing with the actual USCIS for the immigration petitions. But the immigration status of a child who has been reported to be abused, neglected, or abandoned shall have no bearing on either the care or service rendered by DCF to a child or on judicial proceedings. So for the dependency, you can find it on Chapter 39 of the Florida statutes. It's filed in children's court. Dependent child is defined at 39.01.15. Various judicial actors and parties are involved, and it's recommended to proceed through other avenues for seeking SIJ findings if the child is living with a caregiver, even if that person is not a legal custodian. Because if the child is living with a caregiver, the court may not find that the child can be declared dependent if that child's needs are being met. So what to file in dependency court? The notice of appearance, a petition for adjudication of dependency, birth certificate of the child with a certified English translation, death certificates of the child's parents, if applicable, the UCCJEA, which is the Uniform Child Custody Jurisdiction Enforcement Act, and the affidavit of diligent search and inquiry if the whereabouts of one or both of the parents are unknown. This is continuing. What else needs to be filed? There's a motion for entry of the best interest order, motion to extend jurisdiction until the child's 22nd birthday, a proposed order of adjudication, proposed order extending jurisdiction until the minor child's 22nd birthday, acceptance and waiver of service of process from the child's parents, if applicable, proposed best interest order, predicate order for dependency cases. So that was phase one. I can't really talk a lot more about that because I don't handle that part of the SIJ process. But that's the crucial part, honestly. Once that's done, that's the hardest part. And if we can get those orders entered, then we move on to phase 2, which is filing the SIJs with USCIS. So what do we need to include in our packet for that? So we need a cover letter. We need to enter our notice of appearance with Form G28. We need to also file Form I-360, which is the petition for immigrant juvenile status. We need the certified copies of the predicate orders that have the SIJ findings on them that came from the juvenile court. And we need proof of the child's age, most often in the form of a copy of the birth certificate with certified English translation if necessary. The I-360 adjudication process. USCIS confirms that the predicate orders are bona fide and that the special findings are present. USCIS can interview an SIJ applicant or request additional evidence. These are called RFEs. An RFE is a request by USCIS for more information. Reasons for an RFE can include insufficient evidence of birth, lack of certified translations, missing initial evidence, factual basis for the best interest order determinations, lack of language confirming that the court order is final, etc. Now, for the I-485 application, which is an application for legal permanent residence, if the priority date is current, one can file the I-485 application concurrently with the I-360 petition. If filing concurrently, one may also file an I-765 application for employment authorization. You should file Form I-912, which is a request for a fee waiver, because there are fees for those two forms. If a priority date is not current, sorry, that was a misspell right there, is not current, wait until priority date is current. The forms that I mentioned can be obtained from uscis.gov. So visa bulletin and priority dates. There are caps on the number of visas available for each category. SIJs fall within the employment-based fourth preference category. To determine whether a visa is available, you must cross-reference the applicant's priority date, which is that date that the I-360 petition is filed. And then you have to cross-reference that with a cutoff date on the latest visa bulletin, which is found at https://www.uscis.gov visa bulletin info. And you can actually click on that and you can get more information regarding the priority dates and the cutoff dates by clicking that link. So the countries right now that are impacted by visa backlog are Guatemala, El Salvador, Honduras, and Mexico. So if the child is from any other countries, you can concurrently file the I-485. There shouldn't be any issues with priority date not being current. But if the child is from one of these countries, you need to make sure that you look at the visa bulletin for those countries. So if the priority date becomes current, what to file now? So let's say you've only just filed the I-360, the priority date was not current at that time, and now it becomes current. So what to file after that? The cover letter again, a G28, which is your notice of appearance, and it must be in blue paper. G28s always have to be in blue paper. That lets immigration know that this case has an attorney representing. And so it just kind of, it's easier for them to realize that. An I-912 request for fee waiver with the predicate orders included in support of indigency. The I-360 approval notice, because we're assuming that, the approval for the I-360 must have been entered already, right? So you can't do this unless the I-360 has already been approved and the priority date is current. Then you also would file the I-485 application for permanent residence, the I-765 application for employment authorization, proof of the child's age, which is the birth certificate with the certified translation. And then you must also send CL medicals, which is completed by a civil surgeon approved by USCIS, and they must be in a sealed envelope. It cannot be opened. And you must also send 4 passport style photographs. you would file this entire packet to USCIS, PO Box 805887, Chicago, Illinois, 60680-4120. I always send these with certified mail with return receipt requested. And you keep a copy of all the documents you submit for your records. So after you file the SIJ application, the first thing that you're going to get is a receipt notice. You may get the RFEs, like I mentioned. The child will be scheduled for a biometrics appointment, so you cannot miss that notice. So you always have to make sure that you get your mail, because when the biometrics letter comes, it gives you a date and time that you must show up to get your fingerprints taken. And it doesn't really give you much time to prepare it. I think it's only like 10 days notice, or 2 weeks at the most, that you get this, and you must then be available to go get your fingerprints taken. And then an interview can also take place if they want to. Sometimes they're approved without the interview, but a lot of times they do require the interview. If the child happens to move during this time while the SIJ is pending, then you have to file the AR-11 to keep the address current. Path to citizenship. If the youth obtains legal permanent resident status, he or she can file an N-400 application for naturalization, citizenship, after having been in legal permanent resident status for 5 years. So citizenship has a few added benefits, such as the ability to vote. You cannot be deported for certain crimes, and travel is much easier. But legal permanent resident status already gives you most of the benefits that citizens have, but citizenship does give you extra benefits. So that's something to keep in mind. It also is recommended because if you do not file for citizenship after 5 years, then every 10 years, you have to keep renewing your legal permanent resident card. So after you have citizenship, you never have to renew anything else. Like once you are a citizen, you do not have to ever worry about filing anything. Nothing's ever going to expire. It's like a permanent status. For legal permanent residents, every time the card is given, it's valid for 10 years, and you have to keep renewing it. It's kind of like a driver's license. Like you just have to keep renewing it every 10 years. So possible risks of SIJ petition. If the SIJ petition and adjustment of status petition are denied, the USCIS and Immigration Services can transfer the file to ICE, which may use that information to initiate removal proceedings. But no Department of Children and Family Services staff member may attempt to place any alien child in USCIS custody. No such status check or other contact shall be made for the purpose of seeking the child's or the family's detention by USCIS. So practice pointers for SIJs. So check to see if the youth has had any interactions with law enforcement and has a criminal record, because if they do, you need to find out what happened. You're going to have to submit everything regarding that with the arrest. The child must have already complied with any orders made in the criminal court. So just check on that. Check to see if the youth has been deported already or has an outstanding removal order. Check to see if the child is in removal proceedings. So besides SIJs, other relief that may be available to immigrant children are U visas, T visas, and Violence Against Women Act, the VAWA. So the U visas are available to immigrant children who have been the victims of certain serious crimes and suffer substantial physical or mental abuse as a result. Immigrant must have cooperated in the investigation or prosecution of the crime and must obtain certification by law enforcement agency for us to be able to file a U visa. I see this type of cases where the youth has been sexually abused by a step parent or even the parent, the biological parent. So even if for some reason an SIJ was not done, the child would qualify for a U visa under that scenario. A T visa is available to immigrant children who have been victims of severe form of human trafficking. No certification is required, which makes it a lot easier to get these cases filed, but a certification is recommended. So you would go through ICE to get the certification. So most of the time they don't grant those either. Violence Against Women Act, the VAWA, that's available to immigrant children who have been battered or subjected to extreme cruelty by a United States citizenship, by a United States citizen or legal permanent resident parent. So that could happen in a case, let's say the child was being abused by a US citizen step parent, because like maybe his mother married a US citizen and then that US citizen spouse became abusive and was also abusive to the child. The child can also file for VAWA. If for some reason the mom is not filing, the child himself could file. If the mom files, the mom can attach the child as a derivative. But I have seen cases where the mom in one case already had conditional residence, the child had no status. So the mom didn't need to file a VAWA, the mom just needed to file a removal of conditions. But that child in that case was also abused, so I had to file a separate VAWA case for that child. Let's see. So some helpful resources are listed here for the USCIS.gov. That's where you get a lot of the forms, and if you go on the site, you also get a lot of the requirements for each form, and it's very informative. You should definitely get familiar with the site. It's very helpful. Then this is also ICE, www.ICE.gov. That's another site you can look at. The Customs and Border Protection and the emergency medical coverage for immigrant youth. And I think that's it. I think I finished a little early. If you guys have any questions.
That was great. A lot of information in a short amount of time. So I'm going to give everyone a couple minutes to process and type in their questions. We had a question way back at the beginning. Someone asked juvenile court judge only. I'm not sure what that was referring to, but maybe the person who asked if you can type some clarifying info in there, that way we know what you're referring to. So we had another question come in from someone in Palm Beach County. It said one of the requirements is the eligibility for long-term foster care, but Palm Beach follows state law, not the federal definition. Any ideas about arguing that state court should follow the federal definition rather than the Florida statutory definition?
I have not seen that happen. Like I've never had a USCIS send back anything for not having long-term foster care. As long as we can show that the child is not able to be reunited with one or both of the parents. Some of my children are not even in foster care anymore, and I can still file these cases.
Okay, that's good to know.
As long as there's jurisdiction retained by the court.
Okay. The next question is there any place we can find a sample SIJS predicate order with correct language for Florida state law?
Yes, I can send that to you, Christy, and then you can share.
Perfect.
I can send you like the motion, like a sample motion and a sample order, and then you can share it.
Perfect. Making a wish list. So I'll also send out the PowerPoint and any other resources Anna sends me along with the recording of the video. Next question is, what if the child could be reunified with one parent but not the other?
That's okay. That's okay. I have filed cases where the child is actually living with one of the parents, but was found in that case, for example, that child had been sexually abused by one of the parents, by the father, but the child was actually living with the mother at the time, but the child was still declared dependent as to that one parent. So I know it doesn't make sense. Like I question it myself when I start doing these cases, like how can this child be declared dependent? But you only have to show it as to one parent.
Okay. All right, any other questions before we let Anna go? Oh, I see another one popping up. So a follow-up on the question from Palm Beach County about them following state law rather than federal law. The judge is refusing to find the youth eligible for SIJ status, I guess based on Florida statute rather than federal.
Can you send me that email of that person, and maybe I can email with her to see like the facts in that case?
Mm-hmm.
Yeah.
right, so
You can send that to me.
yes.
I don't know why that's happening.
All right. We have any other questions before we let Anna go? All right, it looks like that was it. Thank you so much for all the information and for answering all of our questions. Oh, one more question before we finish. Just got it in under the wire. If you were to give tips to Department of Children and Families, what would they be?
You mean for the dependency process? Is that what she's asking? Because I don't do that part of the case, so I don't, I'm not really sure what the tips would be from coming from my end. I guess just make sure that you have the birth certificate, because that's a huge issue that I find when I get the cases. Sometimes there's not a birth certificate. So when I file the cases, sometimes I have to have like secondary evidence of birth, and that creates a lot of issues for my cases. So if they can somehow get that figured out at that state level, that would be helpful.
Okay. Well, thank you so much, Anna, again for the second training in a row. And thank you everyone for your attention and your good questions. I will be sending out the PowerPoint and any other resources Anna would like to share along with the recording. It should get to you by tomorrow. And you can reach out to me if you have any questions. And I will send the CLE credit as soon as I get it. Hope everyone has a good week. Thank you again, Anna.
Thank you.
Bye-bye.